The Fourth Amendment protects you against unreasonable searches and seizures. So the threshold question should always be, is something even a search? And if it is a search, the next question is going to be whether that search was reasonable. Now, under the Fourth Amendment, and the Supreme Court has told us numerous times that there's certain ways to make that search reasonable. For example, the officers can always get a warrant, or some exception or justification may apply to make that search reasonable. In Katz, which I'll post here above, you'll be able to click on it and watch it, I've discussed whether the police officers can listen to you over the phone and whether that was considered a search. The Supreme Court in that case told us that yes, it was in fact a search, and so the officers needed to have a warrant in order to listen to you. In this case, we'll discuss whether installing a pen register device on the phone line is considered a search. So stay with me and we'll learn some more.
We'll hear arguments next in Smith against Maryland.
In the Supreme Court case Smith versus Maryland, which came out about 12 years after Katz, the question became whether installing a pen register on a phone line is considered a search. A pen register is a mechanical device that can record and monitor the phone numbers that an individual dials when he calls another person. These are the facts that the Supreme Court heard during the oral argument.
The case of Michael Smith presents an example of the modern technology, if you will. Using the telephone in the privacy of his residence, he took an action to exclude what has been known now as the curious ear. He certainly did not expect that the police department, acting through its agent, the telephone company, would seize the numbers that he dialed. And so we come to the first important factor that has to be considered with the use of pen register devices and similar type of devices.
Are you suggesting this couldn't be done without a warrant?
I'm suggesting
It couldn't be done under any circumstances?
Oh no, I believe that with a warrant it can properly be done.
The Supreme Court began to analyze these facts by recognizing that there is some guidance from Katz versus United States, which told us that something is going to be deemed a search if an individual has an expectation of privacy in whatever is being seized. And that privacy has to be one that the society is ready to accept as reasonable.
£182.
Number of alcoholic beverages consumed per week?
Why do you need to know that?
Well, they want to know.
Well, I'm sure they want to know a lot of things, but I don't want my intimate details auctioned off to the highest bidder, willy-nilly.
I'll put 0. Marital status?
Pass.
Profession?
Irrelevant.
Food allergies?
I'm not going to be eating here.
Are you allergic to sticking plaster?
What a ludicrous question. I'm not answering any more of these, really.
Do you smoke?
Stop it.
Do you wear dentures?
Madam, listen.
When was the last time you ate?
Ah, a pertinent question, at last. Yesterday lunchtime. Thanks for asking. I had a tuna sandwich. Toast was soggy, but...
Did you drink the laxative solution?
Yes.
Did it work?
It was as advertised.
Did you evacuate your bowels?
I drank copious amounts of drain cleaning fluid. What followed was fait accompli.
Sir, what I'm asking is if you were...
I shat. Okay? Good. It, again and again. It was like a terrorist attack down there in the darkness and the chaos, the running and the screaming, okay?
Fine with me.
Good. Gross invasion of my privacy, this.
Wait till they get you in the back.
The Supreme Court decides that you do not have a subjective expectation of privacy in the phone numbers that you dial because those phone numbers appear on your bill at the end of the month. Those numbers can appear in a phone book. And generally speaking, you understand that in order to make a phone call, one way or another, you have to convey those numbers to a phone company that eventually places that call for you.
No reasonable expectation of privacy, and I would go so far as to say that in a great many cases, although it's unprovable inherently, there is frequently not a subjective expectation of privacy. The user of a telephone knows, to go back to the days, however long ago they may be, To go back to the days when this was not done mechanically but done by human communication, one said to the operator, Millie, get me George, or get me Sam down at the grocery store.
Operator?
Operator, there's been a bad accident. 2 cars head-on. Please get a doctor and an ambulance.
Can you give me the address, please?
It's right outside my house.
All that's done now, Your Honor, is that we communicate and impart that information, the number we wish to achieve, to a phone company who is not statutorily barred from disclosing that information to third parties. Unlike communication between the party calling and the party called.
And even if you personally thought that the numbers you were dialing would remain confidential, the Supreme Court tells us that your expectation was not one that society is ready to accept as reasonable. And the reason is because you assume the risk. The same way as you assume the risk that when you go to the bank and you deposit your earnings into your account, that the teller would be able to tell your financial information. Here's the same thing, that the company would be able to see the phone numbers that you actually dial. If you watched my video, Cats versus United States, that I posted last week, now you of course are scratching your head and trying to understand how is it that when you're talking on a public telephone, that's deemed a search, yet dialing phone numbers from your home phone is not a search. I will leave you with those thoughts. In the next couple of weeks, I'll develop the case law even more, and we'll talk about the new technologies that are making these searches a whole lot different than what we saw in 1960s and 1970s. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.